we do pitch days every Wednesday. Register online, and it's a great way to get feedback, and it's required to be accepted into the program. So if you have any interest in joining an incubator, go to startupnv.org and get more information. So without further ado, I'd like to introduce Craig Macy, who I would describe as a serial entrepreneur, and he's going to be our speaker today, talking about the importance of startup documents.
Sort of, yeah.
Yeah, there you go. Thank you.
All right, well, so I'll give you just a really quick background so you'll understand the context I come from when I talk about things. I went to law school, immediately got out of law school and did startups. Did not become a lawyer guy. So this was 95. Went to Silicon Valley, was there for 10 years. Did a series of startups. First one we took public, and then sold it to Oracle. Killed the next one. The next one, the VCs killed it. We got offered $300 million for that one. Did a company in China. Ultimately ended up in Reno after about 10 years. At that point, I was tired. Doing startups is exhausting. And then became a lawyer because that's easier. You go in, you wave your arms around, you tell people what's going to blow up, and then you leave. And you don't have to make payroll, and you don't have to raise money. You don't have to do anything. So did that for a while, and have gone back and forth in law, mostly in IP and emerging growth, back out to startups and all that. Recently left the law firm I was with, and now I'm back as a chief product officer, chief technology officer for a couple of companies in Reno. And still do a little bit of law on the side. So my context is there's almost no startup / growth document I haven't had my fingers on, whether it was drafting it, fighting over it, litigating over it, something, somehow. So when I started to put this together, I realized, wow, first of all, there is no key startup document. It depends on what goes wrong. That's your key document. So I'm going to give a bit of a blast of a lot of different things. Some anecdotes of problems that come up, things that if you overlook them, could collapse you sooner than you think. But the other part was it became immediately apparent going through it how little lawyers know about most of these documents. In other words, take for example, and you'll see this as we go through it, you have a patent attorney who spent some number of decades, and they know patent documents. That's pretty much what they know. Patents and a little bit of licensing. But there's 100 others that are potentially equally as important. So the point to get to there is whether it's a mentor, a lawyer, an advisor, you or me, never get in this habit of thinking you really get an idea of what of some document or something that you're trying to handle. There's a pretty good chance you're missing something, or the other person is missing something. And I still go through this every day. Yesterday with a lawyer fight over some loan documents, and one person thought they knew something they didn't know, and then the fight ensued over a debate, which shouldn't have been one. Point being, somebody who was a 30-year expert in securities law knew nothing about a loan document, enough that could have been a problem. So I'll put that in there. So now, having said it, now I'm going to try to sit here and talk like smarty pants about a whole slew of documents, but I'm going to give that caveat that no one's going to really know. So this is the disclaimer because I'm still a lawyer and a licensed attorney, that I'm not giving you legal advice. This is instructional. If you have questions, you need to engage an attorney. So I'm not responsible for anything. All right. So I put this up here for who I'm affiliated with. The two companies on top are the ones that I'm CPO, CTO for. The bottom left, I still consult with the law firm Fenimore Craig with their Venture Accelerator program. And then the one on the right is my own small firm where I do sort of subscription-based legal work for small startups. In other words, they pay me a small amount of money to be able to call, review docs, and do things on the fly when they come up. All right, so why does all this matter? This is really the only strategy point as we kind of go through individually after this. There's a whole bunch of things when you start thinking about docs and what you're going to do with them, how you're going to use them. and there's two parts to it. You got the documents themselves, and then you got how you're going to manage them. And so, I spend a significant amount of time with companies that haven't kept track of their documents, so they can't find them, or the ones they have are the wrong ones, or they've got a bad version, and so they become incredibly inefficient in trying to run their business because they can't find documents or trying to create them on the fly, or go recreate history when they can't do things. So some of the decisions go into the management side of efficiency. Fundability is a big one. I don't even know how many times I've done and gone through due diligence, and documents can make or break it. The absence of documents can make or break it. We'll get into some of that. Cost. It is expensive for the systems, and it's expensive to get documents done right. And so you're going to have a balance. The question, most people are not going to have enough money to go and do everything you're going to see on here. So you end up having to cherry pick. Where are you going to take your risks? Which goes to the next one. The balance is cost and risk. Everything you do in these documents is supposed to help mitigate your risk. And I usually tell people too, that it's from a law perspective, but it's documents in general. This is not about when things go right. It's about when things go wrong. There's about this much of your documents have to do. But hey, if everything goes right, if we all get along, if we're super successful, if there's more money than we know what to do with, you probably won't even be referring to these documents. It's the little provisions of when everything goes wrong that it all falls apart. So you do have to, when people, like things you shouldn't say to your lawyer, I'd really like this document to be more friendly. No, that isn't the point of it. It's that risk mitigation that you're always supposed to be focused on. Control has to do with the ability both to control the documents themselves, which has to do with the management system, but then I'll also say the control that comes with your company or other things that are dictated by these documents. I put security up, and you can put privacy with it too. It's such a hot issue right now that everything having to do with what and how you manage your documents becomes relevant. Most document management is done by email still, in terms of people treat that as a knowledge base, bad idea. They do all the collaboration over email, bad idea. They send things, they send wrong versions, so it can be a huge problem. Where does it come up again? Acquisitions. I've watched acquisitions die for a lack of an invention assignment. Literally didn't get a deal. So because of one document they didn't have. So you can't overstate the importance of going into acquisitions and having your documents squared. And then accessibility, when you're choosing your systems about how are you going to make things accessible. And there's lots of ways to do that. If any of you use DocuSign, that's a good example of sort of how you can move things to a workflow, have it accessible to who needs to have access to just the individual documents without really thinking about it. That's the end of strategy. But what does it really matter? This is all about dodging landmines. You got to choose with your limited money which landmines you want to try to avoid. And sometimes it's dictated by the type of company you have. If there's a lot of products liability, then you take one focus. If you're a tech company that's IP, you're focused in a different way. If you're very service-based, it's yet another. And so when you're looking and you're trying to decide, hey, every one of these stinking documents, the lawyer tells me it's going to cost $1,000. So how am I supposed to do that? One option we'll get to why you're not going to do it is just go off and try to do it yourself. But there's some of them you're going to have to pick, and it's very dictated by your business. So that's why I don't like the 10 most important documents. No, not true. It's going to depend on your business. And so you have to sort of be conscious of, all right, the most important thing, or the thing that I hear about companies in my space getting destroyed on is this. I want to make sure I get this right. Pay somebody to help you. So, which will go right into this. It's a lot riskier than you think. Do it yourself. So I'll just try it myself and I'll fix it later. It's not a good idea for the important stuff. I understand that, yes, some of it you're going to have to do that way because of financial constraints. But you have to recognize that you're sitting on a time bomb. And if you don't have the opportunity to fix it, say you do go through a raise and you've got money coming, you go ahead and you go in and you clean up your docs. You'll hear about that. Oh, we need to clean up your docs. That sounds really soft, like it's not a big deal. It's a huge deal. And you're literally taking a bomb apart, trying not to trigger anything. Templates, there are no such things. Every document I do or everything I see is very tailored to the company that I work with. And so I've never seen a template that works. Even an NDA. I'll just pull an NDA. No, I can tell you 15 questions about it might not be right for this particular arrangement. Do you need non-circumvention? Do you non-solicitation? You needed this, you needed that. So, and so they vary. Is it mutual? Is it one way? Is it this? Is it that? So people will say, oh, I'm just going to go get a template. Where can I get a template? There isn't such a thing, which is number 2 thing, never say to a lawyer, because they probably don't want to help you after that, is, can't you just give me a template? Don't you just have something you can give me, as if they don't do anything? Don't say that. Even if you believe it, don't say it out loud. So boilerplate, that's another. So, oh, but there's so much boilerplate in here. It may look like boilerplate, but somebody did their job. They fixed it. Maybe 90% of it. A provision may be 90% boilerplate, but we're still going to tailor it with some slight wording changes, because that's what lawyers do, nuances. Which goes to the lawyer question. They don't know what they think they do a lot of the time. And so they're going to try, but it's the point when you see with all the documents that I'll throw up on here, you have to kind of temper that a little bit with, okay, I need to get the lawyer that's focused on the thing they know. It's like, I don't know if any of you do software, they have this notion now of a full stack engineer, which is ridiculous. Nobody can know everything in the stack. They're only good at one of those things, and they're marginal at the rest of them. And they kind of cobble your stuff together until it breaks. It's not much different than a lawyer who says, oh, I do everything. I'm a generalist. No, you don't. You do 1 or 2 things, and the rest, you cross your fingers that it's not the landline. Reuse. And I'm going to put 2 of these together because I see this all the time. And not throwing mentors under the bus, I'll throw lawyers under the bus too, is people will say, oh, well, I did this deal here. Just use my convertible note from my last deal. What makes you think it's any good? Nothing. Just because it was used somewhere and it happened to be okay one time doesn't mean it's applicable to your circumstances. So be super sensitive to the mentor that wants to hand you their docs from the last deal they did. It's ripe with problems. Then state specifics. A lot of these documents have very state specific stuff. And not just within the docs, but the docs themselves. So for example, Nevada has not done a good job of publishing the law, but it's the law here that you have to have a privacy policy on your website. It is a law. So there are very specific things about documents themselves and where they're applicable, depending on the state. And then online services, there's a laundry list now of clerkies and all these other things that you can sort of get documents from, or document generators at the law firms. You go in and it asks you 5 questions and it gives you a document. I will tell people they're better than nothing, and I have a ton of resources on the last slide that you guys will have that you can go look at. It's better than starting from scratch, and it's better than randomly pulling something off the internet, but it's still got its limitations. So online services are progressing, but you can't completely rely on them. So the balance, dollars and risk, that's everything you're doing. How much can I spend? I tell you, if you give me $1 million, I can get rid of most of your risk. If you give me $0, I can't help you. So it's somewhere in between those two is where you're trying to get what you can tolerate. And so pick your landmines carefully. Not going to talk through it. There's a million statistics on the internet about document this and document management that. I don't know whether any of it's any good or not. But I pulled it anyway and said, yeah, well, that doesn't help me much, but at least there's stats. So the bottom line is, if you had to distill it down to one sentence, documents matter. So there you go. I kind of put some arbitrary categories based on pulling how the world had, in other discussions of startups, carved the documents up. And I'd go one step farther. It's really not just startups. It's probably through emerging growth that this is the kind of things that you're talking about. We're going to go through some of the documents, but we're also going to kind of blast the laundry list of things that kind of fall under these categories. It's slightly arbitrary, but to the point, if you're pointing at any of these things, why I say lawyers aren't necessarily good at all of them. There's employment lawyers, there's finance lawyers, there's those that do securities law, there's those that do corporate formations, there's those that mostly sit in commercial contracts. So, and they usually don't know much about the other stuff. We can all talk about it. We know we're really good at the words, but it doesn't mean that we have the ability to truly give you the surefire correct answer. So, this is the most important document. Does anybody know what that is? There you go, somebody does, yes, the TPS report. total project summary report. It's from a movie. So, all right. So what I'm going to do as I go through this is kind of blast out bunches of examples of the documents that go within here. You could literally spend an hour and probably a lot more on some of them, talking about any one of the documents I'll show you. So there's no way to go through and say, all right, let's go through a buy-sell agreement in detail. I can't quite do that. So, but what I can do is to give you a sense of the kind of stuff that falls in here and maybe make a few comments as we go through based on, I'm going to mostly draw on my experience of sort of the anecdotal, easy to digest stuff. Again, I am not going to get into the weeds on it. That's just going to annoy everybody, put you to sleep. So, and some of these we're going to hit in other slides, so I'll skip over, for example, the bylaws and the buy-sell, because there's some stuff to talk about that separately. So I'll just hit a couple things in here. One of the things I see happen over and over and over again is foreign qualification. It's not another country. It's when you're in another state, you have to register as a foreign corp, foreign company. You're a foreign company in that state. And it varies by state what the requirements are, but if you have an office and employees there, you're supposed to register there. So this gets interesting because people say, oh, well, I'm a Delaware company. Yeah, but are you operating in Nevada? Uh-huh. Did you register as a foreign company? No, I'm a Delaware company. It doesn't work that way. And so you get to pay twice. You get to pay both states. Oh, well, why did I register in Delaware? Good question. You got to have a good reason to having done that. But it's something that gets overlooked a lot. It can have pretty big consequences. I've recently had to deal with somebody in a situation that they owe $100,000 in back taxes because they didn't register. And so you've got to keep an eye on that. And it's good to get counsel on it, not guess. It's a pretty easy question to answer, but you want to be sure you get it right. So that's one I say in passing because I see it a lot. See a lot of license. The same thing will go with it. Well, if you're in the do you need a license to do business in these other states? Possibly too. And then other things we're going to hit sort of in a few of the ones that are important individually. So the articles, these things are interesting. So you've got these articles of organization or articles of incorporation. Depends on your type of entity. And these are the kinds of things you see in here. But you have these series of documents for your company when you create it and when you organize it. And you'll see things, articles of corporations and bylaws for your corporations, or articles of organization and operating agreements. And the thing is, where things actually fall and get organized can vary quite a bit. So you'll hear some people say, this is what's in your articles of incorporation. This is what's in your bylaws. What will happen is these things get amended over time. They get restated and amended as money comes in, and new classes of stock get created and all this stuff. And it can get tricky because people will sneak things into different documents. I just went through this for a circumstance where the articles had a whole bunch of stuff jammed into them of things you would never expect to see them. Protected provisions for the new class of stock. It was all jammed into the article. So protected provisions are if somebody, for example, is going to put in a Series A, it's going to put a bunch of money in your company. In plain English, you're going to say, I get to veto whether or not you sell the company. I get to veto whether or not you take any more money. I get to veto whether or not you take any debt. I get to veto whether or not you issue any shares. And so you usually see those somewhere else. You don't usually see those jammed into the articles, but there was some little funny business going on. So we tried to put them in there to get them by the original investors so they would see. So there's a lot of data. That's why I have amended and restated at the bottom is there's the articles. And if you go and you start your company and you go to Stripe and you click the magic button and you have your Delaware Corp, even the simplest first order document can change over being amended and restated and become this radical other thing, this vehicle of dastardly behavior. So you have to kind of keep an eye on things and keep your history intact. So the other thing is over time, you'll have amended and restated and amended and restated. And you have a series of 7 of things. And if you didn't keep track of it, then you have to go back and try to put it together. And then you're calling your lawyer and you're begging them, boy, I sure hope you have an executed copy of that amended and restated from 3 years ago because I can't find mine. Yeah, and it's not the lawyer's job to be your document management system. How much does that happen? Every day. And again, you just cross your fingers your lawyer happens to have it. Here's some stuff you typically see in the bylaws, and best way to think of the bylaws is this is sort of how you're supposed to functionally run your company. The things are going to inform that. Bylaws are mostly for corps, and operating agreements apply to LLCs, but there's a lot of similarity between the two. And again, these are things that you have an entire multi-hour discussion on things individuals. Now, get into some more specifics for startups. One of the things that you have to think about as a startup is if there is more than one of you as a founder, how are you going to deal with all of that? And massive amount of my life is spent dealing with things falling apart. And so and we're going to have a whole bunch of things we go through in terms of agreements that go to the fact that you've got to figure out how this plays. And I'll talk to some of these items because I think it's worth it. So vesting agreement. Often people say, well, I started the company, so I own it. It's all mine. Yeah, but no one's going to put money in your company if you don't have some staggered vesting of your ownership. You say, okay, well, that's okay. I'll fix that later. Okay, but now we got another problem. Because I'm sitting here and all right, well, it's me and Brittany. We're starting a company. What happens if she leaves? Does she just get to take her 50% with her? Well, if you don't have a vesting agreement, she does. Oh, well, that stinks. Well, we call that dead weight on the cap table. Is I just lost half the company to somebody who's going to add no value. I mean, I'm glad they started. I'm glad she put in 6 months and killed herself. But we got another 6 years, and she gets to walk with 6 months. Yep. If you didn't think about how you were going to set the vesting up. So it's not just about, well, the investors are going to want it. It's also about trying to make sure you don't end up with dead weight on your cap table. Because not that Brittany's a deadbeat, some deadbeat decides to take off and diversify their portfolio by hopping across startups. That's the Silicon Valley trick. So, 83B election we'll not get into here. It's a tax thing, and I would waste time and you all fall asleep. But it's super important to make sure you understand when and why you do it, when and why you don't do it. Employment agreement. So here's an interesting one, and I'll give you, again, I'll try to give anecdotes where I can. All right, are you an employee of your company or not? An interesting question. It has big tax implications in the LLC context and how you're getting paid. But more importantly, interestingly, in Nevada, if you're an employee, there is a statute that says everything you do is owned by the company, meaning all the IP. If you are not an employee, guess what? It is not owned by the company. It's owned by you as a contractor or whatever your capacity is. So these things can get, even the littlest things can get kind of tricky. It's important to decide right out of the gate, okay, are we employees or not? And if we're employees, how is that going to work? What is our responsibility? What do we do? How do we get compensated? How do we get terminated? Those go into the employment agreements, and it's important to have something to explain that. IP assignments, the next thing that never happens. People start building stuff in their company, or they bring stuff in and they don't actually contribute it to the entity. And then they split up and say, oh, well, but you didn't assign that source code that you wrote. Yeah, I didn't, did I? That's got to be a tough one for you. See ya. An important thing out of the gate, day one, is to say, look, we need to make sure we have that square. Which goes to the next one, the second most never done document, and maybe the most important for tech startups, is two things. It's confidential information and invention assignment. They're two different things, same agreement. Think of confidential information as kind of a very, very strong NDA where you're saying, look, you're not going to give away any confidential information. But the second part is the most critical, important part, is everything I do is assigned to the company. And everything I do, I will assign to the company. And by the way, just in case I didn't, I promised to assign it to the company. And so there's a lot, it's really hammering home that all the stuff I do gets signed to the company. I have a whole slide on that one, which I'll go through in a little more detail. We just went through due diligence in our raise, and the first thing, and I've seen this plenty of times, the first thing they ask for is, I need to see the CIA of every employee and every contractor since the inception of the company 7 years ago, every one of them. And if you don't have it, they will tell you have to go get it. Now, I've been counsel to these guys long before I went in, so we had them all in one folder. Here you go, and they were shocked. It's like, oh my God, you actually have them all? Every single one of them. We even had to pay somebody to get theirs because we had a disgruntled employee leave. They hadn't done it. We said, look, now's the time to pay him before we have our money, and pay him off to get the document. So it is for tech companies, it's a live or die. And even not just tech companies, others too. If you've got anything in there that's IP related, it can kill a deal. It can kill an investment. It can kill an acquisition. And then promissory convertible note. So why would I put this in a founder agreement thing? Well, sometimes you loan money. So you can either put it in and get stock and that's how you things. But there's a lot of tricks you can play by loaning money to your own company. Why do I lie? So I've used this once in a prior company I had. So I loaned money, and my note said that I would have the option when we did a raise to convert that into preferred stock. The investor doesn't really like that. I'm like, yeah, I bet you don't like that. Maybe you should pay me that money back instead, which they gladly did. So I kind of was able to get some liquid out of the raise without having to factor it that way. So, well, they're just paying back the loan. If I hadn't had it converting into preferred, they would have said, no, we're gonna write that thing off because that's just a contribution to the company. But here, I had something to trade. So there's things you can do in different ways with different tools. So I just do that in as an extra there. All right, so here's another half of the shareholder agreement. So this is Brittany and I again trying to figure out how we're going to get along. This is an interesting one for lawyers because this is an agreement between the shareholders and the lawyer represents the company, right? So everybody has to go out and get their own attorney and fight. And the lawyer can't tell anybody what to do. All we can do is sit there. What's best for the company is that we have this. Now you all go and argue and then come back and tell me what you think. And so, and it can get really dicey, especially if there's any tension between the individuals before they get in there. So, right at first, so think of it this way. It's mostly about falling apart. So think about it. You can always think about shareholder agreements. What happens if this all falls apart? Right of first refusal is a notion of, well, do we have the right to purchase back whatever you have if you're going to leave? Or another part of the right of first refusal is if you're going to go out and sell and dilute, does everybody have a chance to continue to hold their position by purchasing more? So you'll see those things in the agreements. You'll hear phrases a lot, tag along and drag along. I'll do drag along first. Drag along is, and these are super important when they're not there. Think about how bad this will go when I say it. Drag along is the majority decides to sell. And what this means is they can make the minority sell too. So we're going to sell to another company. Drag along means, no, you got to sell yours for on the same terms we are, so that they can't hold up the deal. The tag along is similar, where if the majority is going to sell, if they're going to sell a majority of the company, the minority can force the majority to include them pro rata in that deal. So it's a little bit of both to kind of protect the majority from being held hostage by the minority and vice versa. Gets overlooked all the time. Saw a deal yesterday.
They use the words drag along and tag along actually.
Drag along they do. Tag along is see co-sale. Or see tag along. But drag along I always see that way. Interestingly, it'll vary on I never hear drag along called anything else, but the other two I hear said interchangeably. And I get confused a lot because I'll hear co-sale. Like, co-sale, it doesn't sound right, but which I think is partly why people don't use it because it's confusing. Break up, what do you do when you break up? And I got another slide so I can kind of go through 10 ways you break up, what do you do? So I'll skip that part. Voting agreements can be in there. Vesting schedules, we just sort of talked about. Again, that's why I said things can be in different agreements in different places. What are the restrictions on who you can or can't transfer to and when? I'm just going to keep going. I'm going to go fast because you're going to see there's tons of stuff in here. This buy-sell agreement's an interesting thing, and think of that as the breakup. What are you going to do when these things happen? Okay, well, I need to know what the purchase price is going to be. So I decide, let's say we bring in a third person, and we got to get rid of Rick. Sorry, Rick, keep putting in the bucks, but she is just a problem. So how do we get her out? Well, minus a way to get her out, we can't, okay? All we can do is bribe her or shut the company down, both of which I've seen happen. So, okay, so when we're doing this buy-sell agreement, whether it's a separate agreement or an agreement inside of one of the others, we've got to decide what that price is going to be or how it's going to be determined. Is it a fixed price now? Is it a multiple of value later? What is it going to be? So you have to get this price. And what about if she dies? What happens? Does somebody inherit her interest? Oh, we don't want that. I can't stand her family, so we don't want that. Well, how are we going to pay for it? Oh, we better get some life insurance. You have a provision in there. In the case of death, we get it paid for by this life insurance policy that we have over. What about if she's divorced and it goes to her spouse? Oh, God forbid. So don't want that. No, I don't want her spouse in there. How do we go about terminating employment of one another, and for what reason? What are the situations that come under that? There's lots of writings about good cause, bad cause, good reason, bad reason, and how that could fork. A default under the operating agreement. Example of that is you're all supposed to put in certain capital amounts at certain times, and you just decide, I don't want to. I'm not going to do it. Okay, well, then you're out. You have to. That's the deal. So there'll be provisions under there for a default under what you were supposed to do. Let's see what else is worth hitting on. That doesn't. All the rest of it's pretty. Yeah, all the rest will be straightforward. So that's why it's important. Does that stuff happen? Oh man, all the time. Because think about what the odds are of success. So there's a lot of times there is some value left, and there are things you can go do, but you can't do it if the whole thing just falls apart because founders start going like this, which happens a lot. So. Equity compensation. There's tons of documents and things that go with this, and if you're not familiar with it, when the time comes up, you will be. There's no reason to unpack it. This is a whole securities discussion. The one I always point at is the 409A piece. There's a lot of different theories on when you do this and why you do it. But the one thing that is for certain is don't fail to do it at the times you absolutely have to. It's good to get counsel on it. Attorneys will disagree on when you ought to do it. I have my own personal opinion. I just do it every year no matter what. And it's not that expensive, and it was a choice I made a long time ago. I lived through a phase called backdating in the 90s where people would do the date of an option to favor the employee they were trying to get in because there was so much volatility in the price of the share. So you could basically, all right, well, you're going to start at the end of January, but we're going to date your option grant back on January 1st, which effectively means you're kind of robbing for the rest of the shareholders. People went to jail for this. CEOs went to jail with orange jumpsuits. So I'm kind of sensitive to the valuation stuff and maybe hypersensitive. But a 409A simply says an outside party, Silicon Valley Bank, somebody goes, this is the value of your company. And this is the fair market value, so price your options according to this value. One share equals this much. And you are safe, you're clean, no problem. That's a plain English version of what a 409A is, but it's something worth understanding because you're the one that's going to have to make the decision and you're the one that will be on the hook. Unless you get a lawyer to write an opinion letter, then you go.
For example, if you're taking a job in a startup where they're offering a stock option plan, that's something you should be asking for.
Not a bad idea because they should have already done it. The key moment you're supposed to do it that nobody will disagree with is when you put a stock option plan together and issue your first options, that is the triggering point in all cases for 409A. There's a bunch of other ones too, but that's the one that no one's ever going to debate. If you come across one where they're giving out options and haven't done that, you guys better go do this. Now, the negative is, it might go against your interests, at least in theory, is it has to be the fair market value. So what if they're giving you options really low in price as a strike price, and they know if they go get a 409A, it's going to bump the value up $1. Your option price is going to go way up. You kind of like having that low option price, yeah, except that maybe it's not valid. Guess who gets to pay penalties and fines and all this other stuff if the IRS decides to call it out later on? You do. So the employee gets hit, the company gets hit, everybody gets hit. So it's just one of those where I don't know why everybody plays games with it. It really isn't worth it. Just know what the value of your company is and price everything appropriately. By the way, the 409A firms will work with you. I mean, there are a lot of variables, especially in a pre-revenue startup. Jeez, I mean, it could be anything, So you give them the data and then, you kind of nudge a little bit about this is what I think, and you you try to find out if you and the one who's doing the valuation can get to a point where you sort of agree. Employee documents. So there's a whole bunch here. Deal with this all the time. Again, this is another one where a lot of lawyers will be armchair employment lawyers. And employment law is tricky because it usually goes contrary to what you think is logically what things should be. So employment law is dangerous where a lot of law will say, okay, yeah, that logically makes sense. Employment law often doesn't. And so the things you think you can do or you think were right were wrong. So I slow roll in answering employment law questions and go to an employment lawyer before I'll try to say, if I know something for sure. The law changes a lot too. And if you're not following cases, it flips 180 degrees. Oh, it was different yesterday. So these are important to CIA, and we'll get to that. That'll keep coming up everywhere as I bang on home so much. The employee handbook's a tricky one. Whether you should or shouldn't have one is debated amongst different people. But then you get into how many employees do you have? Do you have 15? Do you have 50? Different times trigger different things, and where are you going to put your anti-harassment policies if you don't have a handbook? So if you do have a handbook and it's not good, is that worse than not having one? Yes, that's much worse. So you better have a good one. Well, how do I get a good one? Do I just call my HR outsource? No. The HR outsourcing handbooks are often bad, they're outdated, and they're often not state specific. So you probably have to get it from an attorney. Oh, that costs money. Yeah, so it's one of those things. So those are this is just an example. I won't go through all. The employee file and performance data is just an important one. I don't care how big or small you are, is just keep a record of stuff. If nothing goes wrong, it doesn't matter. If something goes wrong, you'll be so happy. So.
Is an offer letter a binding contract?
No.
Okay.
No, it's not, but you could word it in a way that it would be, and there are ways to do it. But I'm going to say generally, if you do it properly, it's not, and if you write it properly, it's not. All that being said, a great way to end yourself is to just put out offers and then not. I changed my mind. I mean, there'd be an extenuating circumstance that would come up. Oh, well, we made this offer, and like we talked about, it was contingent on us closing this round, and the round below, we don't have the money. The person's not going to say, well, you're tired anyway. I mean, so I've never really seen it become a problem. But all that being said, it's a good question how you word it. There are ways to word it that will make it softer than it could be otherwise. You can always put contingencies in there too. I have seen letters that became employment agreements, which is really strange. Somebody writes a long offer letter with tons of detail in it, that it sort of becomes more than an offer letter. For example, I wouldn't put in an offer letter a whole bunch of information about stock. It would say, you'll be granted stock contingent on board approval. Okay, so I didn't tell you were getting stock. I said contingent on that. So all I have to do is not get board approval. But so you have to just be sort of conscious about it. This is employment law, and I go like this because it's whatever I think is right. I'll often, if I say too much, I'll go. All right, so the confidential information invention assignment agreement. Everybody signs it. Everybody you can get that gets anywhere near your anything signs it. Somebody just, an intern's going to hang out. Well, I'm just going to have my high school teenager in here coding and doing some logos. Everybody signs one. This is where the assignment of your IP will be mandated, and even if you have a fight and you put a patent assignment in front of them and they refuse to do it, this still carries the day for you. It will include excluded inventions. So software developers hate these things more than anybody because I wrote this app and I got these 7 things and I got the code I stole from my last company and I got all this stuff and that's all mine. All right, then you got to list it out. I don't want to list it out. Well, and then there's a debate. A really sophisticated, high-paid software developer will hold out and say, I'm not listing out anything. Anything that I have is mine, and I want it just to say anything that exists before I walk in here is mine. So that's excluded. Or, often there'll be clauses in here about, hey, anything you want to work on that is not ours, you're going to claim is not ours, you have to tell us ahead of time, and we'll have a written record that says, hey, you said you're gonna build a, some app. We agree it's not ours. We have no interest in it. It's better for both, because they're like, great, you said it wasn't yours, But it also means that if you're in that fuzzy zone where it could have gone both ways, you don't have to fight. Yeah.
You mentioned in Nevada, it sounds like it's a default that employees, any of their IP belongs to the company. Is that
if you say nothing, but that's a one-liner. It's a one-line statute. It's literally just one line, and that's what the statute says. But you don't. But you could say
if you don't have this agreement.
If you don't have this agreement, the employees, but it's not necessarily everything. It's patentable inventions. It's a one-liner. This is a huge document versus a one-line statute. You don't want to hang it. That is the last thing you want to hang around. That's the
I'm concerned about the default of that one-line document, that one-line provision.
Yeah.
So without this document,
an employee, anything they do in your company that falls within the patentable inventions stuff, language in that one-liner, belongs to the company.
Whether they do it for the benefit of the company or if they're doing it during their employment.
This is why it's a one-liner and it's not so great, right? Is you're going to have to debate and fight over what all it means. It's just a one-liner. You do not want to rely on that. These are, it's there. At least it's there. It's from a company perspective. It's better than having nothing. It's better than the contractor situation where it apparently means the default is it. But if you want to look it up, it's NRS 600.500. And it's a one-sentence thing. It's really short. And then you say, oh, I mean, maybe what they did is in there, So, but this is what you rely on, not that. So this is what you need. But barring it, at least you kind of start to think. If you say, oh, what does the case law say? You're not going to find anything to that. So, confidentiality, and I could beat on that. Company ownership of emails, big deal. It's always a big deal. Email accounts, people doing stuff from their personal accounts instead of their. I don't know how many times I run into the disgruntled whatever, somebody gets fired and they can't get the emails. But, we didn't have his emails on a personal account. Well, who owns the emails on his personal account that were done for business? Well, depends what it says or doesn't say. There might be a non-compete. That's you're allowed to do that in Nevada. You're not allowed to do it in other places. So you have to be sensitive to where the employee is to a degree. Whether they can solicit. The last one's one that comes up a lot that I don't see many places. People go and they say, all right, we want a Twitter account, a Facebook account, an Instagram account. And then I go and create it myself. And then it's like, well, who owns it? And I leave. I'm like, why? I set it up. It's mine. It's got my name. Everything in it is mine. I just happen to brand it as it could be a big debate. I mean, it's a lot better if you just said, hey, anything you're doing in the social media stuff on behalf of the benefit of the company within the scope of your employment is ours. And when you leave, part of your exit is you're obligated to make sure all of that is transferred over to us. Better still, you never do anything in your own name. You have a company account that has its own credentials and you do it under that. It's how everybody does that, right? No, almost nobody does that. Almost nobody. And I don't have it in there. I think I have it somewhere else, but it's passive and domain registrations, anything have to do with domains. The other one becomes a hot fight. Whoever's the guy who's handling the IT stuff or the founder that did it, set up the website and had it under his name at GoDaddy. Good luck getting it out of him when you get in the fight. Executive employment agreements. These are sort of different. They can be contractor agreements. By the way, so the employment lawyer, wherever the employment lawyer is, would say possibly there is no difference. Every contractor is an employee. In particular, there is no such thing as an executive contractor. But that's for the employment lawyers to debate. Either way, you still see the same terms in here. These are the kinds of things that come up. They're a little bit different. They have different flavor than typical agreements. You have to be sensitive to it. Sometimes people will freak out when they, engage. Maybe the sixth person they bring in is a contract CFO type, and all of a sudden he gets this thing that looks, wait a minute, you want what? And you get this, because it doesn't look like other people's employment agreements. So you just have to be sensitive to what it looks like. Fee shifting is having to do with you paying his legal bills if you get in a fight. I mean, there's certain things in there that are fairly typical of these agreements. So when you get in, you do need to take a look at ahead of time and say, all right, what does an executive agreement look like? It looks different so that you can negotiate it properly and know what you're going to negotiate. This was just a bunch of stuff on intellectual property protection, since that's an area I work in. There's a massive number of documents in here, and they're all very subtle and very substantial in terms of what their implications might be, and even in the flavors of them. A couple of the really big ones, interestingly, and I'm not going to get into the bits of the law stuff, but administrative account credentials. People leave a company and you don't have an account in software world. We got a GitHub repository and nobody knows how to get in and get a source code. Or the Wi-Fi password, I don't know what it is. So it goes on all the time. There needs to be a document with the administrative account credentials in it. It's a document. It's an important document that doesn't exist in most companies. The systems runbook is another example. Okay, so everybody leaves. Do you know how to run the system up if somebody leaves and it doesn't work anymore, especially if you're, say, a software as a service company? No, I have no idea. In fact, I don't even know where our stuff is. Is it Amazon? Is it Microsoft? I don't know. So that's another one that's sort of, again, overlooked, but still falls under this. The website terms of use, people like to just take one and copy it. They should never be copied like that. You can find one as a good starting point, but it really does have to be tailored to the specifics of your business. It's not in here, but I'll hit it because it falls in the same time frame. Privacy policies, people say, oh, I just need to do a privacy policy. There's a whole bunch of stuff you have to think about with that now, too. States are implementing different things. California just implemented a bunch of horrendous laws. If you have European users, anybody that's in Europe, they don't have to just be a resident, they're just there, then you got a whole new legal regime called GDPR you have to comply with. If you don't, and they decide to come at you, they can take 20 million euros equivalent or 4% of your gross revenues. I mean, it's not a game to play with. Privacy is something to suddenly take real seriously. So you don't just copy over a privacy policy and say, if you use my site, I can do whatever I want with your stuff. You are not allowed to say that anymore. In almost any state, you have to have get consents for certain things on the bottom, and you need to store those consents. Then you have document that's a consent, even if it's electronic. You may need to have access logs. There may be a lot of things around privacy that you now have to do. So, wow, that sounds like a lot of stuff. Yeah, the only people that happen to know it are privacy lawyers. So it's tough to get a right answer, but the consequences can be brutal if you get it wrong. Commercial contracts. So this is where I spend most of my time in the law world, and which is also why I can say, gee, it's amazing what, as much as I don't know employment law, how much other lawyers don't know some of these. And reseller agreements are one that I see, I don't know, maybe come up 80, 90% of the young companies I work with, the best way to increase your sales and expand your channel strategy is to get partners. And they're going to be resellers. Well, are they going to be a reseller or a value-added reseller or refer, or are they going to do distribution and have resellers under them? Or are they going to? These are all radically different types of agreements, and hard to get done, hard to get right, and hard to get out of, get them wrong. I'll give you an example. If you give an exclusive to your partner in Germany, German law favors the fact that they invest in that as an exclusive, and sometimes you can't undo the exclusive. So if you gave a German partner an exclusive to all of Europe, you may not be able to undo that contract. So there's sensitivity in picking how you put these things together, in which things are critical and important to think about. But I put them up there just to say, that's a lot of stuff. Oh, is an order form a contract? A lot of times it is, because you forget to attach anything else to it. So you got to be careful of the words you put in just an order form. I could pick any of these other than the order form. I could pick anything up there and spend half the day talking about it for every permutation. But they're documents, then, very, very strategic. Pitch materials. So these are all typical, but let me kind of go over a little bit of why I say over time and the ones at the bottom. You need to store every single time you change them and who you gave them to, because you'll give something and and it'll have some pro formas and some made up numbers for a 5-year projection. And then you go and you change it all, and you happen to see them again somewhere and give them a change. Oops. And now you got to explain. You're not allowed to go, well, come on, we all know that the 5-year projections are made up. You're not allowed to say that. So knowing who you gave what to when and having that all archived, which is a pain to manage, but you do it. And get Dropbox or Google Drive, whatever you're using, and partition that out and saying, all right, here was my November pitch deck. Here was my November 15th pitch deck that went to Sequoia. Here was this one. And so you know what went where, and you can control the information if you have to revisit those people. Or if they start talking. The problem is you'll be, oh, wait a minute. So let me think here. This guy's in Sequoia, his best buddy, the guy is in August. I can't give him different than I gave him. So they share. It happens. It's the team is another one that's kind of important because I see that get noodled with a lot in thinking about how you project what your team looks like. There's some insensitivity to that sometimes about what the wording is or what you do or don't say or how you explain things or people that disappear over time. What happened to that sales guy? The deck over here says, your key sales, where is that person? So just being always sort of thinking about how am I projecting what my team and my key people are, so that I can explain the changes over time. I lost 3 biz dev people, and I'm taking an investment. These are things you see in financing. I'm sure not going to go through all of this. Talked about a couple of the items, but it's worth. Is there anything I want to dig into at all? This guy go for days on this stuff. No, if you get there, it's stuff you'll have to learn to go through at the time. I'm going to run out of time, so I'm trying to race here. Commercial contracts. Oh, it's more commercial contract stuff. I got that twice. Okay. No, there's nothing different than the other one I had, so I got to put it in there. All right, discussion points. So I'm going to go fast. Documents have metadata. People think, oh, metadata, it's just that property stuff on a Word file. No, if you go to, if you're a Unix or Linux person, you take a PDF and you do a metadata on it, you would not believe how much data is in the header information on that. You can learn a lot about where documents came from, who touched them, all kinds of stuff in the metadata. So there are things that clean the metadata on your documents, and you have to think sometimes. Lawyers, in fact, we got a religion with it. I mean, we can't send anything out of the law firm without the system, before it goes out the door, forcing us to strip all the metadata out of anything. So, and I have used it against other people, man. I have found some amazing stuff that I've been able to twist some arms with. So be sensitive to the fact that what you see in your document is only a portion of what's actually in there. Privacy, I mentioned that. I won't go back over it. Document retention, you need to decide how long you're going to keep stuff. Some of it's dictated. The GDPR privacy laws tell you have to get rid of any personal identifiable information within 30 days after you terminate a customer or you're done. So some of it's dictated, but you really do need a policy. So it will help you. You need to know how you're going to store it, and that will both for privacy, access, all those kinds of things, but make a good decision on it so you keep it organized from day one. Litigation, if there's any threat of it, or it will have an impact on what you can or can't keep. What you can't do is go, oh, I think I'm heading into litigation. I'm going to delete everything. Can't do that. So email is its own monster. What I tell people is treat email as the construction of a written record. Don't treat it as communication, as secret one-offs or anything. No, everything in there, assume it's going to get seen, and treat it as this is my opportunity to create a written record. So every email I ever send, the back of my head is, this is part of the story that I would potentially want to tell the court. I don't ever put anything sketchy. For example, if somebody wants to talk about whether or not something's patentable, won't do it over email. Absolutely not. We'll have a phone call. But in the email, we're going to go, your stuff is definitely patentable. I really like how innovative it is. So you're building a written record, and you need to think about it. Because that's how the courts will look at it. Otherwise, there's no point. Don't treat it as your knowledge repository. Careful. Look for it. let's see, why did I have executive summaries there? Don't remember. Audit support, keeping your documents for anything that you might, if you're doing deals with people, they'll have audit rights a lot, and you need to pay attention to what those are, because it might say, we can come in anytime and audit the following 17 things. But if you didn't keep those 17 things and they come in, that is a problem. So thinking about, all right, I look at the audit, I look at what they'll tell. This is something you get debate a lot in these agreements. I'm not going to do monthly audited financials. I'm not going to do it. And you have an argument with somebody about whether or not you're going to do that. The main reason you don't want to is not just to do them, but it's I don't want to have to keep a bunch of crap like that laying around so you can come in and audit me. And so that goes to the second part. Anything you're contractually required to keep. Someone might say, I want an access log. Executed documents, maybe second biggest mistake I deal with is companies don't keep executed copies of things. DocuSign will save you with that. If you start using DocuSign religiously, even if you forget to move it somewhere, it's sitting in DocuSign's repository. It saved the company's butt. They were selling a subsidiary, and they could not, that they had wound up, and they couldn't find the box of documents in their big. They couldn't find it. It was gone, and they hadn't scanned it. And they were able to sell it only because, do you still have that DocuSign account? Well, we didn't close it. Okay, we'll go look. And sure enough, every executed document that they needed was in DocuSign's repository. So, is it a mistake that happens? Oh yeah, and it can cost you the sale of it. The engineering design service provider agreements, these are just beefy, they're beefy agreements, I won't get into it. Managing term renewals. So in these agreements that you have and documents, people often don't pay attention to the notice period. So they're like, I'm going to terminate the agreement with this crappy website provider. Except you had a 90-day requirement before termination, otherwise it automatically renews. And you come up to the last day and you're like, I'm not renewing. They said, actually you are. And you're supposed to tell me 90 days ago. So, well, gee, how do you do that as you grow? You have a spreadsheet. I mean, there's contract management systems that do this, and it's hard, but at the very least have a spreadsheet for the important stuff to say, okay, here's my drop dead date to make decisions about whether I want to stay with this partner, whether I want to stay in this deal, whether I want to stay with this provider. And these are all the resources. So I think she's going to PDF this and send it to everybody. This is just a bunch of places to go look. This is kind of counter to what I just told you about don't use templates, don't go here, don't go there. All that being said, hey, it's there. It's better than nothing. It's a starting point. You can certainly learn from it. There's a whole bunch of different things up here. Some are law firms, some are third-party providers, privacy things, terms of use stuff, all kinds of stuff. So I've used every one of these for something.
I don't see legal zooms.
Yeah, you don't see legal zoom. That's exactly right. That's the one thing I don't use. So I've used no, I used it once, like 10 years ago. Used it again. There's better alternatives to that now. Clerky is one, Stripe is one, that you can get a lot of things done. Most of what LegalZoom is good for at the low end, there's stuff that's better, and for the things it's not good at, you shouldn't be there at all. So, like using them for trademark, bad idea, really bad idea. Trademark, yeah, even worse idea. Trademarks are not as easy as they look. You can get in a lot of trouble just by filing a mark, just for the fun of it. I just want to get a trademark, but you didn't do a search ahead of time, and you just put somebody on notice that you're infringing on their mark, and you get a cease and desist, and it goes real fast. And I see that regularly. But you got to really think before you do certain things. So LegalZoom is not a thing. They're like, come on in, it's cheap. Yeah, come on in, file something. Why not? So yeah, not a big fan. So I made it. There we go. Get in an hour. Questions, comments?
Yeah.
Reputations, criticisms?
Okay, so you got 100 documents there.
Yeah.
There's $100,000 in lawyer fees
That's right.
there. Okay, so you're trying to raise some money for a startup. You're going to raise $100,000 just for the documents.
No, that's why I said the dollar list thing. So I'm not the lawyer that just tells you have to do them. I'm the one that look, there's just stuff you can't do. I'm sure you want a bunch of patents. They're expensive. You'll blow your entire legal budget chasing patents down. So Maybe you're not going to do a great patent. Maybe you're going to do what I call a napkin patent, which is you just scribble some stuff on a piece of paper and file it so you can say you're patent pending. Is it any good? You say you're patent pending and you're not committing fraud. Oh, well, can anybody see it? No, that's the best part. It's secret. Nobody can see anything. So they could be scared of you because you say you're patent pending. But and how much did that cost? $125. But what if I want to do a real patent? Probably anywhere between $5,000 and $15,000, depending on the quality. So, yeah, it's throwaway, but you get to say something on your PowerPoint that you didn't need to say before. I mean, so there's a balancing act with every single thing in law. I think if somebody comes in as a pure lawyer view, there's good and bad, right? But from a business standpoint, if you've got this giant picture of your company and only a certain amount of money, the law can't take up all of that. You know, you got marketing, you got a lot to do. So you're like, really, hey, you know, I'm going to do what I can. And a lot of it I'm just going to blow off, and I'm going to accept that risk. And it's good to know you're accepting it, or not forget to try to come back to it later. But no, you can't say, you're right, it's $100,000. If you literally paid a lawyer to do every single thing that's in there, actually way more than that, because I had patents and other things in there, it's probably $300,000 to do everything that's in there, maybe more. And so you can't do that. It's not reasonable. If you were a giant company, you would. You know? But that's why they have, you know, $100 million legal budgets. But you got to pick and choose. You got to try to be smart, and you got to try to decide where your risk is. And even though I said don't take documents from mentors, sometimes what are you going to do? You're going to take the document from the mentor and cross your fingers. And that's just how it is. I did startup, so I know how it is. You're like, I got to do what I got to do. For me, it's not pleasant because I know the outcome. So it's hard to. I get it, but I know you got to do this. Oh, it hurts. Anything else?
Haven't so much.
Right. So I tried not to get too far in the weeds, but just say there's a lot. So
In summary,
there's a lot.
There's a lot.
Yeah. And
I need
it's,
to go look at all my folders again. With all the
yeah,
documents
I think
and
that part of
see
the
what I have
problem,
in there.
everything in the universe has become a document. It's digital or anything else. I mean, a web page is a document. So it's sort of when I thought, oh, key documents, what's everything? What's not a document? And which one doesn't matter? They all matter.